run the moderation today. We have the returning star from last week, my lovely wife, Jen. So please be sure to thank her in the comment field. And for the first time in a weekend live stream, we have the always steady, wonderful, and amazing Derek, who is typically the man behind the camera. Right now, there's nothing behind the camera. That's the reason why it's breaking right now, because you're stuck with me as your producer. So we've got some interesting things to go through today. For those of you, let me know how many of you in the comment section are familiar with the DeWilde challenge. The DeWilde lawsuit that's going on out of Wyoming dealing with machine guns. It's okay. I'll type it into the chat box. And that way you guys, no clue. Okay. All right. That's fair. It is a case that, to my knowledge, has not been covered much in the gun tube sphere. We've got Indiana, Montana, Florida, Texas, Oklahoma, Minnesota, the People's Republic of Austin, which may as well be a state within a state. Got it. Okay. All right. So the DeWilde lawsuit, and this is not going to be like a full legal breakdown and everything. I just wanted to kind of cue you guys up from this, and then maybe I'll pivot and do a video. I'm in the process of putting together a video on it. So Mr. Jake DeWilde is suing the federal government, challenging not the National Firearms Act. He's taking what I think is a wise approach of incrementalism here, and rather challenging the specific statute that prohibits and bans machine guns as being unconstitutional in a post-Bruen world. For those of you on your lawnmower, Bruen, B-R-U-E-N, in reference to the 2022 U.S. Supreme Court. He is unrepresented. He is pro se, which means he is representing himself. He is not an attorney. But he is a very smart guy. He's a very nice gentleman who very kindly took a call of mine earlier on this week. And I had a wonderful conversation with him lasting almost an hour, where we talked about the lawsuit. We talked about all sorts of different things. And then he very kindly sent me a follow-up email. Like I said, this is a lawsuit. So we're now in the Circuit Court of Appeals. So he lost in the district court, which was kind of to be expected. So district court, as you recall, there's about 94 federal trial district courts. That's where almost all lawsuits start. Okay. Then from there, we go up to one of the 13 federal circuit courts of appeals. That's what the case now is. And then the only thing above and beyond that is, of course, the Supreme Court, SCOTUS, the Supreme Court of the United States. So that's where that is right now, is he lost at federal district court, and now we're in the Circuit Court of Appeals. And there's all sorts of interesting things happening in this case. I've seen people chat about it on social media and groups on Reddit and all that kind of stuff. But like I mentioned before, not so much in the gun tube sphere. There's a lot of people who have a misunderstanding about what this case is. As I already mentioned, it's not challenging the National Firearms Act. That's the act that basically meant that if you want to get your hands on a machine gun, a suppressor, short barrel rifle, short barrel shotgun, AOWs, any other weapon, think about disguised weapons, disguised guns, anything invented by Q from the Bond series. That's kind of a general guideline as to what may be an AOW. These days, destructive devices and so forth, so artillery and so on. The National Firearms Act basically put all that behind a tax wall, among other things. But it really wasn't until much later that we saw the outright prohibition, thanks in no small part to the Hughes Amendment coming from 1986, which was an amendment to the Firearm Owners Protection Act. The Hughes Amendment, among other things, made it that you could not possess any newly manufactured machine guns after early May. I want to say it was May 19th off the top of my head, but it's been a while since I checked that date. I'm sure I'll get fact checked in a constructive manner in the chat box, but I think it was May 19th of 1986. So you are allowed, provided that you are in a free enough state, to lawfully purchase a pre-86 civilian transferable machine gun. Now, as many of you know, that is extraordinarily expensive. That is not the cost that it was 40 some odd years ago, even 10 years ago. as machine gun prices only go one direction, and that's up. There's approximately 175,000, give or take, registered and papered machine guns in the United States. They have accounted for exactly 0 instances of crime. 0. There's been 2 instances where a papered machine gun was used in the act of or the commission of a crime. To my knowledge, both of those involved off-duty police officers. So I don't know how we're going to score that one up. But at any rate, so Mr. Jake DeWilde is challenging this. And there's a lot of things I'm not going to go into just because it's not time yet. And he asked me not to share it. And I'm absolutely going to be respectful. We're all on the same side here. First off, he wanted to thank everybody for your support. I'm definitely under the impression that he's keenly aware of a lot of the coverage, a lot of the attention that he's been getting, most of which positive. It's the internet. There's no such thing as 100% positive. So I know that he wanted to convey his gratitude for a lot of people who are supporting him. And then he also said, I'm just going to read this because I don't want to get anything wrong. So he sent me an email. Hi, Tom. I enjoyed meeting and talking to you on our call yesterday, and I just want to send a follow-up. After giving some thought to our discussion, I think your audience and listeners deserve and would be best served by your understanding of 2 things I'm not certain I gave you yesterday. Number 1, a concise summary of the argument in my case. And number 2, what distinguishes it from previous cases challenging the machine gun ban? To my first point, the big change in my case compared to prior challenges is, of course, Bruin. The test is extremely straightforward. Number 1, is possession of machine guns covered by the text of the Second Amendment? And number 2, is there a historical tradition that supports the ban? These are the only 2 questions that the court must answer, aside from the standing issue. The government argued standing, which they always do. Standing generally gets to the notion, and this is not him writing, this is me explaining. The government's been challenging whether or not he has the ability to sue because he was not arrested in possession of a machine gun. He's simply suing because he'd rather not go to prison for possessing one. And incidentally, he tried to file, as I recall, a Form 1 to possess, to manufacture and possess an M16, much like he possessed in the Marine Corps. So as well, Mr. DeWilde, thank you for your service, of course. So back to the email. Most of the argument in my case surrounds what analysis is permissible at the textual analysis. The government argues that Heller's dicta, D-I-C-T-A, this is me explaining it again. Dicta gets to when we have like the Supreme Court or any court, but when we've got a court who is writing an opinion about something, whether it's the Supreme Court, a Federal Circuit Court of Appeals, when we talk about dicta, we're usually talking about a lawmaking court. So not really trial courts for the most part. We're talking about courts of appeal. Dicta is a concept that you get into in law school and elsewhere, which stands for the premise of oftentimes a court, when they're writing their legal opinion and they're making their ruling on whatever the particular issue is, they may kind of talk about things that may be not essential or not immediately of consequence to the ruling. So for instance, Heller fundamentally, you could say it dealt with machine guns insofar as it dealt with our individual right to possess and own firearms, among other things. But it didn't, strictly speaking, deal exactly on point when it came to machine guns. It was a handgun challenge case, among other things. So dicta would relate to where Heller may kind of riff on some other subjects, which may fall outside the exact scope of what the case is talking about. And in law, when we talk about dicta, dicta is often given much less precedential and therefore binding value as compared to whatever are the 4 corners of the issues to be resolved in the case. So when someone says, as Mr. DeWilde does here in his email, hey, when the court was talking about this, it was dicta. That's an entirely appropriate, reasonable, and fair legal argument and observation saying, look, the court absolutely did talk about it. There's no disputing that. It's black and white. However, it's not relevant and it's not binding law because it was dicta to the case. It was outside the scope of the ruling and the court was just building context or kind of going on a tangent. So And that plays a big role here. So I'm going to go back to the email now that we've kind of covered what dicta, D-I-C-T-A, is. The government argues that Heller's dicta, whether machine guns are dangerous and unusual and in common use and implicitly unprotected by Heller, may be considered at the first question, the textual analysis. My argument is that after Bruin's clarifications, all of the government's analysis refers to historical traditions and must be employed at the second prong. So recall that in Bruin, this is me talking again, there's first the question of, does the law or regulation that we're describing, is this protected by the Second Amendment? Is this something that is going to be protected by the Second Amendment? And if the answer is yes, then we go to, well, the government has to find within the nation's historical tradition of regulating firearms some sort of analog within that historical tradition to show, yep, we've done this before, good to go. It's more nuanced than that, but that's a very fair low resolution. So for those of you who've not encountered that before, that is the law right now, post June 22nd of 2022 from the U.S. Supreme Court. So back to the email. So when he's referring to the second prong, he's referring to the fact that the government is trying to shoehorn into this. The government's trying to say, look, we don't have to get into whether or not there's a historical tradition of regulating machine guns, because machine guns are just not protected by the Second Amendment. That's what Mr. DeWilde is in essence arguing, low resolution version. DeWilde's saying, that's what the government's arguing. DeWilde is saying, by contrast, no. The question of whether or not all firearms, all bearable arms are protected by the Second Amendment, if you read Heller, Mr. DeWilde's view. So really, it's the government that must show why their regulations of machine guns are supported by the nation's historical tradition of regulating machine guns. So the question is this a first prong issue of, is it protected by the Second Amendment? Are machine guns protected by the Second Amendment? Or is this a second prong issue of the government must show a historical tradition of regulating machine guns? That's a very, very, very important point that Mr. DeWilde is putting his finger on here. One that I heartily agree with. So back to the email. This is important because the second prong shifts the burden onto the government, and the record does not demonstrate a historical tradition supporting the ban. They thus would lose. This method of employing Bruin, strictly separating the two prongs, is what most recent cases overturning gun control have looked like. In most post-Bruin cases that upheld gun control, the court disingenuously applied Bruin, if at all, and primarily relied on Heller. As to the latter, so this is now him getting back to what distinguishes his case from previous cases challenging the machine gun ban. Back to the email. As to the latter, my challenge is the only civil challenge I'm aware of that squarely and directly confronts the machine gun ban. That's 18 U.S.C. Section 922 sub O. That's the statute that bans possession of machine guns. This, along with it, also being the only civil case challenging the ban after Bruin, make it unique. He goes on, in fairness, Blount, B-L-O-U-N-T, versus U.S. challenged the machine gun ban, but he arguably lost at the appeals court because his case was frivolous, and then he links to it in the email to me. From prior related challenges, and he's almost done here, I'm familiar with, let me inflect that properly. From prior related challenges I'm familiar with, this is an important distinction when other challenges have attempted to sweep many statutes into a single challenge. House versus Lynch is one example, as well as the offsetted criminal challenges involving the machine gun ban. Courts have not been forced to give an honest shake to challenges around the ban. It arguably gets swept up into the opinion as a small and insignificant issue because everything else challenged in the case passes muster. If any of this was not clear from our discussion, I hope this clears it up. Feel free to use any of or none of this as it suits your video and the direction you're going to go with it. Again, if you'd like to discuss this case further, I'm happy to have another call or we can chat there. Best, Jake. So thank you, Jake. I know that he doesn't entirely appreciably, he does not want to go into a tremendous amount of details involving his case while there's a pending live lawsuit in front of the U.S. Circuit Court of Appeals, which I mean, I'm not pushing back on that, and we absolutely wished him the very best. Had a great conversation, fantastic guy. DeWilde, I'm going to be having a case, or I'm going to be having a video that's going to be going into that. It's one of those issues where I keep picking up the research to do, and then it keeps getting pushed because of reason XYZ. So anyway, let's take some of your questions. What do we have here? So this one comes from Black Dog Brewery. I heard that the Second Circuit of the Supreme Court has finally issued a decision on at least 2 of the appeals against New York's Concealed Carry Improvement Act, which was created 1 week after they didn't like the Boone decision. Apparently, the decision is over 200 pages. Yeah, it's 261 or 263 from memory. Could you please weigh in on that and what actually happened in these cases? So I got about an hour into reading it. I don't know, Friday. I was reading it when Jared at Guns and Gadgets went live talking about it, which is about par for the course. And I love Jared. It's not an anti-Jared remark. He's just on top of everything. I created a list, which let me see if I can click up here and see if I can open up. It's a very complicated case because it tackles so many issues. Let me see if I can quickly find this. Hopefully I saved it somewhere. Filming. Let's see here. Okay. So the issues that case is covering is the judge, and I'm not looking at the case. I'm looking at my notes of what I was taking as I was reading the case. There's a whole bunch of lawsuits that got aggregated together into one because they're all fundamentally challenging the same law, sometimes in different ways. So kind of the guiding case is Antoniuk versus Hockel, I'm just going to put it in the chat. ANTONYUK versus Hockel, HOCHUL. That's the case name. It's in the Second Circuit Court of Appeals. We're dealing with a preliminary injunction on it, which means that keep in mind as these things go through, there's usually a temporary injunction that gets put into place, which is where the plaintiff, typically when we're talking about it, the pro Second Amendment side, they file the lawsuit and they're asking for a temporary injunction. That's a judge, we need to put the emergency brakes on this, like presto, within days, maybe a week or two, while we litigate this out, because there's going to be irreparable harm to whatever the particular issue is. So we're not talking about a temporary injunction. We're talking about a preliminary injunction, which is something that is typically weeks or maybe in a couple months later or months down the line, and involves a lot more litigation, briefing, and argument than would ordinarily just go into a temporary order. So if the temporary order is the right away upfront, slam on the emergency brakes, the preliminary injunction is let's pump the brakes and let's set the ground rules while this case is working through sometimes years and years and years of litigation. So the plaintiffs here were asking for a preliminary injunction to enjoin all sorts of different things, and enjoin meaning to stop the implementation and the enforcement of all different aspects of this particular law as it's winding through. Now, the reason why this is so important, aside from the fact that you're stopping the law from going into effect, has to deal with the burden of what goes into this. Because generally speaking, so goes the injunctions, so goes the lawsuit. Because one of the key aspects of what the court looks to is whether or not the person moving for the injunction, typically a plaintiff, though sometimes the respondent, but in our case, the plaintiff, whether or not they're likely to succeed on the merits of the case, which is code for, are they probably going to win? So you can imagine, and there's actually more things that they look to in that, but that's kind of the big one. If they're likely going to win, and if a bunch of courts rule that they're likely going to win, they're likely going to win, right? So that's something that is, that's the reason why these injunctions, and when you see videos, whether it's mine or another channel, talking about these cases, sometimes I see comments about people complaining of, why are you covering this at the injunction phase? Why not just wait to the very end? Well, because usually by the time we wait to the very end, I mean, that's like, waiting to cover World War II until April of 1945. I mean, it's over at that point. right? We're wrapping up the details and we're in mop-up mode very often in these lawsuits. So that's the reason why I see me as well as others really cover these injunctions, because these are typically where the decisive clashes and where most of the tension reside that is predictive of the outcome. So the lawsuit's divided into two different sides, which deals with the licensing side and then the sensitive location side. And I'm going to go through this really quickly. The licensing side is basically three different issues, and this goes back to how do you get a license in New York? There's the social media turnover, there's the cohabitation requirement, and there's what's called the catch-all. Social media turnover is where you have to disclose all recently used or in-use social media accounts. We're not talking about turning over logins and passwords. You just have to disclose their existence. You have the cohabitation requirement, where you have to provide and disclose the names and I assume dates of birth and so forth and other identifiable information of everybody you cohabitate with, spouses, friends, family who are maybe living with you, something like that. And then there's kind of the catch-all of just all this other stuff that they throw into it. The courts in the Second Circuit basically wound up striking down the social media requirement, largely due to the fact that it would, in essence, violate the First Amendment when it came to anonymous speech. Again, that's the low resolution version. The cohabitation requirement, they, as I recall, I believe reversed the district court. So the district court struck it down. The Second Circuit Court of Appeals reversed the district court. So they have upheld it on the grounds that the trial court, that's the district court, said it was permissible to look into the character and of the individual applying for license. And character goes well beyond criminal records. This is the Second Circuit Court of Appeals talking, not Tom, just so we're clear. So if we're allowed to look into character, and that goes beyond someone's criminal record, and it really goes into someone's trustworthiness and dangerousness, in the words of the court. So if we're allowed to look into that, and if we agree that we're allowed to look beyond someone's criminal record, then who else better to talk to than the people that they live with? So that was the gist as to how they got into that. The sensitive location side, they look at treatment centers, they look at places of worship, parks, zoos, places or premises where that are licensed for alcoholic consumption, as well as First Amendment gatherings, which is code for protests. I have gotten through approximately 100 pages of the case. I have not gotten to the sensitive locations side. My hope was to get an emergency video up on it on Friday, but good news, bad news. I'm not a full-time YouTuber, and sometimes work, business, real cases, all that kind of stuff get in the way. So I look forward to pushing through on that, but that's where I'm at right now. So I hope that helps out Black Dog Brewery. It's a very complicated ruling. I know that the gist to it is that some things were upheld, some things were struck down, but I don't have all those details yet. So stay tuned. Next one comes from Roberts Lamka 8872. On my way home from a gun show last night, my driver and neighbor said he purchased a CZ pistol from a private sale. He would like to conceal carry as he has a license. However, he's concerned about the possible legitimacy. How does one determine if the firearm is on a registry for missing or stolen guns? I'm certain there are many individuals out there with this very question. Thanks, Tom. Interesting question. Not one I've ever really thought of before. And to that point, you're right. I mean, if you get pulled over for speeding, and maybe you're in a state like Missouri where you have to disclose the fact that there's any firearms in the car, otherwise it's a crime, or God forbid, worse yet, you are in a self-defense firearm case, and only to find out that the firearm that you did a private purchase on turns out to be stolen in, halfway across the country or something like that. That's an interesting question. So I've never seen anyone do this before. I'm wondering whether or not you can basically ask the ATF or law enforcement to do what's called the trace on it, where they basically, in essence, take a look to see whether or not there's kind of an all points bulletin out on that particular firearm being reported lost or stolen or anything like that. And of course, if it is, you lose the firearm. But on the upside, you don't have to go through the awkward I was just involved in a self-defense gun shoot with a stolen firearm, which could be tragically problematic because I imagine the prosecutor will be leading with that and their open and close in your case. And I'm not saying that they ought to, because obviously, whether you're using a stolen firearm or not, whether you are a prohibited person who is using a firearm under protection of the necessity common law defense, none of that changes whether or not your so-called shoot was a good shoot or not. So I'm not trying to usurp that, guys, but we all know how prosecutors, not all of them, there are a lot of good prosecutors out there who are not absurdly aggressive and anti-gun. Unfortunately, there are far too many that are. So I can easily imagine them doing something like that. But yeah, so to your question, I bet you're going to be stuck going through law enforcement if you want to take that route. Of course, the other route is don't purchase used firearms, which, to be clear, I'm not saying don't purchase used firearms. But if that's a very harsh concern of yours, those are basically your options. This one comes from DLF Ferg. How often do you get to the range, and what is your EDC firearm and holster? So my range time is weird. I get to the range for handguns a lot more when the weather's bad during the summer or during the winter. I get to the range usually a handful of times a month. For shotguns, it's pretty sporadic. I'm usually there when it's not good golfing weather and when bird season, grouse, woodcock, more recently pheasant and all that kind of stuff is approaching. And otherwise, I'm very fortunate to have some land up north that I can screw around and shoot rifles and everything else at. As far as what's my EDC, my everyday carry firearm, for years it has been an HKP30 SK subcompact, specifically the LEM, which I upgraded to the Langdon Tactical with the light trigger. Really love that. Very small, very compact. I've typically been carrying it in a tier 1 concealed holster inside the waistband at about 4 o'clock. More recently, I've been kind of dabbling in some other things, in part because why not? And I'd like to give any trainers watching the channel like a heart attack. So I've been screwing around with my SIG 365 extra long or extra large, whatever it is. Today it's actually Walther PDP is what I've been using. I had a company send me a holster to review, which I've not done a video on yet. It's called LA Concealment is the name of that. I didn't really know. I'd never heard of them before. They asked, what do you want the holster in? For what firearm? They didn't make it for the HKP30 SK, so I had to choose something else. So I chose the SIG 365 and actually really like the holster. So it's a nice holster. That firearm is such a small grip that it kind of disappears. I run it with a Wilson Combat grip with a couple of the lead weights in there. Before the HKP30 SK, I was married to Glock, and I continue to be in a long-term committed relationship with Glock. I'm not anti-Glock. I also like Smith & Wesson. Shields occasionally break into the list. So in short, what is my everyday carry firearm? The answer is yes. It's a lot of different things, but if I could probably only choose one, I might default to the HKP30. I find that things, once you get the grip back to, because with the subcompact, with the 12-round mag, the back of the grip, see, there you go. If those of you familiar with the fact I often talk about Stoic quotes and so forth, here's a book from Musonius Rufus, who's a Stoic philosopher. So if you imagine this is the grip of the firearm, and the firearm's going this way, if you cut out this back side, that's really what causes all the printing issues. And that's kind of the magic for that firearm, is it doesn't have a lot of that there. So it kind of shoots like a midsize, but it carries kind of like a subcompact, which is the reason why I like the HKP30. All right, the next one's from the Downward Machine. Have you thought any more about my question from last time? You know, I actually was thinking about this. Today was unloading Costco groceries from the car, maybe about 2.5 hours ago. I was actually, and I started to think about, I've got this live stream coming up. I started to think about that a little bit, about what kind of firearm restrictions. So for those of you who were not at our live stream a week ago, I'm inferring it was the Downward Machine asked, basically, do I support any firearm laws or any firearm restrictions or regulations? I don't want to be misstating what you asked, but I think that's what you asked. And I gave what could very fairly be described as a cop-out answer, not because I was trying to cop out the question, but because it was true. The answer is, I've never really thought about that before. I tend to live in Tom's real world rather than Tom's utopian world. And in Tom's real world, I don't get to decide what the US Supreme Court finds to be constitutional, unconstitutional, or what the New York State legislature passes or doesn't. I could give you my answer. Here's what I have as a thought out answer, which maybe this is another layer of a cop out, but it's what I think the Supreme Court is going to do. Because I do think about that a lot, about what direction do I think gun laws are going in 2 years, in 5 years, in 10 years. This is not to be confused with what I want. Let me be emphatically clear. This is 0% what Tom wants to see. This is what I think is going to happen. I think we're going to see no change in the machine gun laws. I'm sorry. I'm pro machine gun. Don't get me wrong, but I don't see it. I've been doing a lot of research on machine gun laws, and I just don't see it. There's a lot of rumor and speculation about the fact that back in Heller 2008, that Scalia had to include some seemingly anti-machine gun language. That's the dicta that Mr. DeWilde is referring to, because he had to horse trade that to get a judge on board to get the majority decision on that. And that kind of stuff's common. I don't think we're going to be seeing a reversal on machine guns. I think that we have a chance at getting some reversals when it comes to and broad legalization of short-barreled shotguns and short-barreled rifles. That would not surprise me. I think that we're going to see, and I don't know about suppressors, undecided on that. But without going into details, because I'm not privy to going into the details, I'm aware that there's going to be, across 2024, some new emerging legal attacks on short barrel shotguns and short barrel suppressors coming out from some surprising areas within the pro Second Amendment crowd. So I'd love to go into details on that, but I'm bound to secrecy on it. So just stay tuned on that. I would not be surprised if destructive devices gets crimped even further, even though, of course, nothing ever comes of it. But let's face it, if the legislatures are going after 50 BMGs, same deal. Yeah, I don't know. I'm gonna continue to think about it because it's an interesting question. But I'm sorry, I'm not trying to give you a cop out. I've never really thought about it. My default position towards firearm regulations is I don't like them. My default position towards gun control and gun laws is that everyone I've ever met, I believe, accomplishes far more harm than good, categorically, across so many different dimensions. So does that mean that there's not a couple good ones out there? I don't know. I don't know. I'll think about that. I'll continue to think about it. So thank you for joining us. This one is a super chat coming from Luis. Can you do an EDC pocket dump at some time? So an EDC pocket dump, for those of you who don't know, is, it is what it sounds like. You basically, generally speaking, for almost every YouTuber I've ever seen, an EDC pocket dump is this BS thing where they stage they're pulling out knives and guns and all that other kind of stuff. My EDC pocket dump, which I can assure you is not staged, if I can pull it out. There. Walther PDP. Wasn't lying. And this appears to be, yeah, this is a tier 1C holster is what this is. It's looks pretty new because it is. I'm trying that out. 15+1. So I like Walther as a brand. I'd like them a heck of a lot more if they weren't about 5.3 inches long or something like that. But there you go. EDC pocket dump challenge accepted. Otherwise, look, I'm familiar with what a lot of those videos are online. Most of the time, I mean, maybe I'm cynical. I think that they're mainly just kind of product placement shills or something like that. But this was not. This was very real. So thank you, Louise. This one comes from Thomas Harrison. What is your legal opinion about your state attorney general signing an amicus brief with the federal court in support of California's standard magazine ban? I mean, I'm learning about that right now as I'm reading that. Am I surprised? No, I'm 0% unsurprised. Wisconsin's attorney general is no friend to the Second Amendment at all. I've been told, I don't know if this is true, but I've been told that he has blocked any updates or revisions to Wisconsin Department of Justice's concealed carry curriculum. There's like a PowerPoint slide curriculum, which has some great things about it. As somebody who may or may not have played a contributing role in its development, very small one back in the day. But there's certainly a lot of improvements and changes I'd like to see in it. And my understanding is that the Attorney General has said, no, you cannot do that, which makes no sense. That's not even a pro-gun, anti-gun thing. That's just are you pro-human and do you want a better, safer concealed carry class or not? So no, I'm 0% surprised to read that, Thomas. 0%. This one comes from Copper Stacker. If a round gets stuck in the breech due to a malfunction and the firearm has to be taken to a gunsmith that way, would the firearm legally be considered loaded even though it cannot be fired? Well, my official answer is check your local listings. That's interesting. So the two laws that you're competing against here is one, if you have live ammunition that's chambered in the firearm, that's generally considered to be a loaded firearm. And even if you have a loaded magazine inserted into the magazine well, it often doesn't even need to be locked into place. It just needs to be kind of breaking the plane. No round in the chamber. That is also often going to be meeting the definition of what's considered a loaded firearm. But on the other end of the equation here, we have the fact that for something to be considered a firearm, it generally must be operable. My bet is that the fact that it's inoperable is not going to overwhelm the definition of a firearm statute, which I think is what you're asking me there, Copper Stacker. And consequently, I'm going to bet that, and again, this is my off the cuff, not legally researched, not legal opinion, but I'm going to bet that that's me considered a loaded firearm. That's just what I'm going to guess there. But that's interesting because you do have those two laws living in tension with each other there of we absolutely have ammunition inserted into it, but it's also presumably utterly inoperable. One concern I would just throw at you there is the fact that oftentimes the government, when in the context of a criminal case, the government individuals who will test your firearm will to determine whether or not it's operable, or for instance, whether something is a machine gun, will go to extraordinarily unreasonable lengths when they're writing their conclusion. I did a video talking about the, the gentleman down in Florida. I'm blanking on his name right now, but about what the government did to basically convict him of selling or participating in the sale and promotion of these auto key cards. So I can go into that more if people want, but the point being is they did insane stuff to try to get him, and get him they did, but I don't think there's anything remotely ethical about what they did. So that'd be my concern on that, Copper Stacker, is the X factor definitely works against you, which is what are the government individuals testing it what are they going to reasonably conclude? Not what I want to be putting my money on. This one comes from Mike Yu. Mike Yu, thank you for being a member. Always great to see you. Common commentator in the comment section of videos. Tom, I live in a state that has a duty to retreat. Is there any exceptions or challenges that can be made to protect me if I need to defend myself or family? So generally speaking, your common law exceptions are going to be necessity. That's going to be probably the biggest one that's going to wind up coming into place as what we would call kind of an affirmative defense or common law feature. So we're talking, although it can be found in statute as well. So when we're talking about necessity, it's, yeah, I understand that there's this law, you've got this duty to retreat, but, and maybe I did not reasonably exhaust it, but I couldn't reasonably exhaust it because of reason X, Y, Z. So you can claim a necessity issue, obviously defensive self, defensive third person, if you're out with your family or something like that. As you mentioned, your family. So I don't know if there's somebody who maybe is not as fast or as nimble or as spry as you are, Mike. I don't know if you have children, if somebody's older or getting on in the years, or maybe you just got a bum knee or something like that. So I would say number one is, did you exhaust your duty to retreat options? And even if you weren't in exhaustion of those, is there necessity, defensive, self-defensive third person as a direct challenge and workaround to that? So I think that's the gist as to where I would go with that. So thank you. This one comes from XSSFD Lieutenant. Will it be possible to get a ruling to clarify the Heller in common use in regards to such as self-defense? Yeah, I think what you're referencing here, correct me if I'm wrong, I'm going to tab open the chat box to see if there's any clarification as I take a stab at this. One of the emerging battle lines that we're seeing happen in court is that the anti-Second Amendment folks are continuously claiming that now you can only use firearms that are intended for self-defense, or you can only use firearms that are in common use for self-defense. So much like how the anti-Second Amendment crowd pre-DC versus Heller claimed that, well, you have a sporting use test, right? The Second Amendment is just about deer and duck hunting. And any firearm that's not for sporting use isn't protected by the Second Amendment, which of course is, that's just crazy. Like, I don't know what to tell you. That's the definition of lunacy right there, that we have a constitutional amendment to protect deer hunting. And I deer hunt. I'm not anti-deer hunting. I'm just saying that's the definition of insanity right there. So, and now they're trying to redefine, move the goalpost to say that the only firearms that are protected are those that are in common use for self-defense. So presumably, commonly carried semi-automatic and revolvers, semi-automatic handguns and revolvers, and maybe common home self-defense firearms. Now, if you follow the logic on a lot of, well, the lack of logic, but if you follow the arguments of what a lot of anti-Second Amendment people say, I heard one politician say that there's no firearm that's in common use because the majority of Americans don't own firearms. It's less than 50% of Americans own firearms. Now, a recent study that I did a video on said it's 52% of households, but less than 50% of Americans own guns. So I saw one politician claim that the minority of Americans use firearms, and as a result, there's no firearm in common use, which again is an absurd reading. As to your question, though, circling back around to it, of do I think that Heller is going to be, or do I think that the Supreme Court is going to be pushing into this territory? Well, they did talk about some of these issues in Katano when they were talking about electronic weapons. I think they ruled that 216,000 electronic weapons was in common use, and they did not decline it as being a dangerous or unusual weapon, which is a whole separate discussion. And by the way, on the topic of dangerous, unusual weapons, I'm really excited to pass along. This might be premature, but you guys will be the first ones to know. I got another interview commitment from none other than the preeminent scholar on the history of 16th, 17th century, and as well as 18th century English weapon and militia law. Why is that important? Because that's where we got the Second Amendment. This person is the recognized preeminent author cited by the U.S. Supreme Court in multiple cases, and Lord knows how many other cases. Miss Joyce Lee Malcolm, Dr. Joyce Lee Malcolm, who I had the pleasure of speaking with a couple days ago, and I got an oral commitment for her to come on the channel. She's a very busy individual. I don't know when that's going to be happening. My hope is sooner rather than later, but I've read her book some time ago. I'm going to have to do a refresher on it now, but I read her book, very fascinating book on the history of English militia and weapons laws, which of course directly goes to dangerous and unusual. Who are the militia? Who's the Second Amendment? What's it about? All the history. Like, she wrote a book on that. It's out there. So I've never done a video on it. Probably should do a video on that book. But kind of thinking about, I should do that. The name again, I'm going to type it into the comment field. There. Joyce Lee Malcolm is the name of the author. And her book, if you look it up on Amazon, it's the one with the red cover. And maybe I just have one behind me. No, it's where I read books, not the library where they go once I'm done with them, or while they're waiting for use. This is like the garage for me. Her book's out on the pavement, so to speak. It's a red. Give me a moment. I'll just link it. And unlike virtually every other channel, I am not getting a cut of this. This is not an affiliate link. I'm just looking this up on Amazon right now. All right, there we go. It's in the chat box. It's $33 on Amazon. To Keep and Bear Arms: The Origins of an Anglo-American Right. So, at any rate, and she wrote other books as well. That's kind of her magnum opus, I think, in a lot of respects. That's the big famous one. And that's one I read a long time ago, and I've started to reread it. At any rate, so she will be on the channel at some point in the hopefully imminent future. And I hope to get into topics such as dangerous, unusual, and all this other kind of stuff, which is just simply not the case. Circling back around to your question, the issue that the U.S. Supreme Court has gone into as far as what kind of weapons are protected, in a nutshell, if you read Heller, are weapons that if you were called to the militia grounds, what would you muster with? What would be the weapons that you would be bringing from home? What are the bearable arms that ordinary Americans are using for self-defense? Handguns, rifles, shotguns, all that kind of stuff. So that's the gist as to where that law is right now. So thank you for the question. This next one comes from Tim4CN. Can I hire you for 2A cases? If the answer is you're in Wisconsin and you have a state criminal case, yes, you can hire the firm. I started a firm that actually just turned 10 back in October. We have 27 attorneys now. We cover different areas of law, not just criminal. We've got different attorneys in different divisions. But when it comes to, am I someone who sues the government? I candidly lack the skill set for that. My background is almost entirely in criminal law. And as a result, I can read the cases, and I'm trained in reading, obviously, courts of appeals, U.S. Supreme Court decisions, and discerning from them what's important, and hopefully being able to cogently summarize that and communicate it. But writing it and drafting it and knowing all the particular timelines and all that kind of stuff, that's just not what I do. I'd be happy to participate as a consultant or to throw in my 2 cents in the background. But yeah, as far as someone who's kind of the tip of the spear, so to speak, not my thing. So, okay, next one comes from Alexander. Oh, I'm going to butcher this. I apologize. Tenayuka. Hopefully I got that right. I await the chat correcting that. Is the outcome on SBR going to be the same for SBS? So is the outcome for short barrel rifles going to be the same for short barrel shotguns? I don't know if this is in reference to when I mentioned the fact that I anticipate there's going to be some emerging legal challenges in short barrel rifles and short barrel shotguns. I imagine that they will be dealt with pretty similarly to one another, but we will see how they go. So if you're asking me to make a prediction, I'm going to predict yes, so goes one, so goes the other. But obviously, that's not a guarantee or anything like that. This next one's from Mr. Thomas Question. Is that the name? At any rate, Mr. Thomas Question writes, National Firearms Act of 1934 was out into law due to the growing organized crime gangs at the time. Is the government saying that we, the people, are organized criminals? I mean, I'm certain that there's people in government who will absolutely say that civilians should in no circumstance own firearms. I have encountered those individuals. There was a case which, for obvious reasons, I can't go into details on, but there was a case where I remember going into the prosecutor's office. I don't remember what the charge was, but it was something that involved, may not even involve firearms, but maybe it was a felony charge. At any rate, I go into her office and she deliberately ignored me for a bit, as prosecutors will sometimes do. This was maybe 10 years ago now. And the gist to it was that she said that she knew my client owned firearms and she wanted to give him a felony because she thinks that no one should own guns. And she saw this as her part of doing the Lord's work to take another gun owner off the streets. I truly don't recall the specifics of the case. I don't recall it, at least from memory, of it being like a nasty case, one involving extreme acts of violence or anything like that. I really, as I sit here, I can recall the prosecutor's face. I can recall her words. I don't remember her name. I do remember the county. I certainly don't remember the client. But I just remember that because you don't tend to forget things like that. I've had similar encounters with other prosecutors. And again, guys, to be clear, not all prosecutors are like this, okay? There are many very reasonable, sane, even pro Second Amendment prosecutors out there, just as there are sheriffs and so forth, okay? But you're right. So you encounter people like that. I don't know if she would specifically characterize everyone who owns a firearm as a member of organized crime, but maybe if she knew that, you were part of a pro-gun group or subscriber to this channel, maybe she would change her opinion on that. I don't know. But yeah, no, look, it is what it is when it comes to the National Firearms Act, at least for now. And I hope that changes some days. This one comes from Jay Stallard. How can someone donate to his legal challenge efficiently that is avoiding the GoFundMe expense? So I'm assuming, Jay, you're talking about when I was going through Mr. DeWilde's case. Short answer is I don't know. I'll ask because he doesn't have an attorney. He's representing himself. And I'd love to go into more details on that, but I don't want to, I'm not going to break the fourth wall of my conversation with him. I will ask him if there's any kind of funding. And if you can check the community tab on the channel, that's where I post all of like the quotes of the day. If I get an update from him related to that, Jay, I'll post it up, but I don't have an answer for that right now. Thank you. This next one's from 9mil. Do you have a concealed carry insurance recommendation and why them? I'm seeing a trend from week to week. Let me ask this in another way. Who do you use for concealed carry insurance and why? I'm just going to pause for a moment. Does anybody in the chat section know what I'm going to say here? Just wild shot, hazard a guess. Anyone? There's a delay, by the way, between when I'm taping and when you guys see it. So, right, yeah, there it is. USCCA, United States Concealed Carry Association. And that does not mean that I'm against others. Here's the really short version of it. I know USCCA gets beaten up by a couple different individuals out there who frankly support other companies. And as I understand it, though this may not be true, they've got close personal connections, and I don't know if they're monetary or not with other companies. So there's a couple individuals out there that like to beat up on USCCA, but yeah, attorneys on a retainer insurance will not work. Someone is the Guns and Glory shows supporting attorneys on retainer. So here's the really quick rundown. All these groups, attorneys on retainer included, are going to conduct their own assessment as to whether or not you have an arguable case of self-defense. They will all do that. And I know USCCA very, very well. I've talked to multiple attorneys at Law Shield. I've read the membership agreements for all those groups, including AOR, Attorneys on Retainer, as well as CCW Safe. They will all do the same thing. Rule number 1 on the 3 rules of will attorneys on retainer cover you is something to the effect of, do you have an arguable case of self-defense against a felony charge, a possible felony charge? It's something like that. My knock on attorneys on retainer, and let me be clear, I'm not anti any of these groups. I think attorneys on retainer, who I have an active phone call out to, by the way, where I talked to them, talked to their staff, identified who I was, said I had questions, please give me a call back. And I gave them my questions so they could think about them. One of my questions is basically your current, they wouldn't call it a policy, but your current engagement letter, your current retainer agreement specifically excludes representation in misdemeanor cases. Well, I'll tell you, the vast majority of self-defense cases that are not clearly white or black, and most of them are shades of gray, the vast majority of our legal retainers, when it comes to defensive gun use cases, are on misdemeanor charges. They're not felony cases. Because the majority of the time when you pull your firearm, there's no shots that are fired. The majority of the time when you pull your firearm, the bad guy sees that and they run away. So if you are in a no shots fired situation, the majority of the time, depending upon what your state's local laws are, and of course this is going to vary, but at least here in Wisconsin, as well as some attorneys from other states that I've spoken with, these are misdemeanor cases. So my 2 big knocks on attorneys retainer is they like to push the fact that, hey, we're not going to exclude you for carrying an illegal weapon or an illegal place. And that's all great. But as a practical matter, that hardly ever comes up. But as a very equally practical matter, what does come up is misdemeanor representation, which they won't represent you on. So that's a hell of an exclusion to have. Likewise, many states, including Wisconsin, will bar you from attorneys and law firms from posting bail. So if somebody has attorneys on retainer here in Wisconsin and in many other states, you have no bail coverage. So they've got some things to work around, and I'm aware of some other issues that are out there as well. I wish them the best. I think their product needs some significant overhaul, and I wouldn't be surprised if they have to do multiple things to bring it up to where any of the insurance companies are. So that's kind of where that is. As for why do I like USCCA, aside from just on a personal level, that I've been working with them for about 8 years, and if I'd been given an employee number with them, I think someone told me I would be employee number 17 when I got linked in with them, and now they're like, I don't know, 800 or 1,000 or some sort of crazy high number. They allow you to choose any attorney you want. They give you a blank check. Whatever badass attorney you have in town or in your state who knows all the right people, they're winning all their cases, that's USCCA. That's the person you can hire if you want. There's no limit to coverage. If you're choosing a qualified criminal defense attorney in your state, there's no limit to how much they're going to pay for. My knock on Law Shield is that, as well as CCW Safe, is that you have no choice on your attorney. I will say that at this point, I have met a handful of Law Shield attorneys. All of them have been good. So, just all I can just do is just be honest with you guys. I'm sure that there's weaker ones out there. Don't get me wrong, but I have liked I've met 4 Law Shield attorneys. I've liked all of them. CCW Safe has a pretty scary provision that says that they get to manage your litigation, and also that you basically agree to waive attorney-client privilege for them to communicate and to manage litigation, which is pretty scary. So I don't want to hype that up as being the end-all be-all that they're going to sink your case, because all these companies, they all want the best for you, because if they align their values properly, what's best for you is going to be best for them. I think like in life and in business, you have to look for the win-win situations and put yourself in the win-win situations. And I either know that the USCCA looks to do that, or I will give the benefit of the doubt to these other companies that they're trying to do the same. They're trying to put a win-win situation for their members or for their clients. So if I had to rank them right now, I would put USCCA at the top. I would put Law Shield number 2. I would put CCW Safe because I don't know how scary their managed litigation is. I would drop them to a 3rd. I would put Attorneys on Retainer a very distant 4th place right now. And look, if you like their attorneys, if you like those guys and you want them to represent you, keep in mind that, to my knowledge, USCCA is being more than happy to stroke them a check. I don't know about happy, but they'll stroke them a check, is my understanding of, if you want them to be your attorneys and they're eligible and they agree to do so. That'd be pretty funny though if someone did that. So that's the reason why I like USCCA. A lot of the details are always wandering as far as who's better on bail and all that other kind of stuff. So I don't really kind of get into those weeds. I did make a video. I actually think I recorded it about a month or so ago, or the better part of a month ago at this point, where I talk about, I go into all the details on this. It's like a 25-minute video, and I keep saying I'm going to release it next week, and then things keep happening. So my goal is to get it up before Thanksgiving, and now here we are pushing Christmas. I did add to the video because, like I said, I did reach out to Attorneys on Retainer because I really wanted to get their reply on this. Like, am I misreading it? I don't think I am. I think it's pretty black and white. But they have my number. I mean, I'm pro them. I'm less than fond of their support for gun control and red flag laws, which if you read Mark Victor's 2019 U.S. Senate campaign, you can go right there, assuming he didn't take it down, but you can go and look at the fact that he supports different communities passing different levels of gun control. He supports homeowners association restricting guns. He supports red flag laws. So I'm not fond of that, but just as I did last week, I would ask you not to hold that against him as an attorney, because look, the vast majority of defense attorneys out there are rabidly anti-gun. And that's not my sense of it. My sense is that I hope he's a good guy and that he's a qualified attorney. And look, if you think he's the cat's meow to get you out of a jam, I would still say get USCCA, because you can still hire him or anyone else that you want, including on misdemeanors. So just a thought. This one comes from Michael Dunn. Does your wife, Jen, carry as well? Do you always carry, Jen? Do you? She's one of the people who's copy pasting your questions into a shared document. So she does carry. She's actually a really good shot, a really, really good shot with both handgun as well as rifle. She's cross-eyed dominant, so she's finally figured out the trick for wing shooting a shotgun as well. But yeah, she does carry. She's a big fan. Not as often as I'd like, but she does carry. She carries a SIG 365 in the Filster Enigma holster. So she's a big fan of active wear and that kind of stuff, and that usually doesn't have belts, so she has to have some sort of way of carrying it around. So next one comes from Mark Eller. Michael, thank you for helping me to shame the wife. There's a 0% chance this will backfire against me personally in any way, and as soon as this live stream's done. This next one's from Mark Eller. Why can't CCW reciprocity fall under full faith and credit? Yeah, so the full faith and credit clause of the United States Constitution is what that's in reference to. I don't have an answer for that. What I will say, Mark, is that I'm someone who is, look, if we get full functional reciprocity at the federal level between states, obviously I'm very much in support of that. But I'm also very hesitant of my very practical gun rights being regulated from DC, which isn't to say that I trust Madison really any more than I do DC. But I do have concerns about the fact that we're rushing towards a solution, and I can't help to think sometimes what new problems are on the waiting on the other side of that door. So this next one comes from Donnie Vinson. Is it against the law to protect from criminals with ammunition that is made to expand when it hits the target? So is it illegal to use expanding ammunition? Well, most ammunition's expanding. I mean, ammunition can fall in multiple different categories, right? You've got full metal jacket, you've got hollow point, you've got, of course, soft point, so a lead exposed tip. You've got frangibles, you've got, I suppose, wax and wood bullets, if you really want to go back here quite a bit. To my knowledge, New Jersey's the only state. Now that's code for check your local listings here. But to my knowledge, New Jersey's the only state that prohibits individuals from carrying hollow point ammunition outside the home. I think you're allowed to use hollow point ammunition inside the home, just you're not allowed to carry it outside the home. So with that exception in mind, and any other exceptions that may apply, no, it's absolutely not illegal to take advantage to protect your life and the life of your family with the same ammunition odds are that local law enforcement carries to protect their lives so they can go home to see their family. This next one comes from Mr. Thomas. Is it possible the NFA Act of 1934 will be repealed? Possible, yes. Unlikely, yes. I just don't see that happening. I think, as I mentioned before, but I'll briefly summarize here, don't confuse this with what I want to see. This is just my prediction. I don't think we're going to see a change of machine gun regulation. I do think there's a chance that we'll see changes the way that short barrel rifles and shotguns are regulated, first and foremost, and maybe secondarily suppressors. Next one comes from Nick Ferry. Tom, you talked about your EDC having a light trigger, and I just wondered about that because I've heard that when you modify a carry gun, they can easily use that against you. True or false? So I ordered mine from the factory. As I recall, I think Langdon Tactical has 4 different trigger weights. I don't have their website up on the screen. They've got an extra light. They've got a light. I don't know what they call the other one. And then I think they have one that maybe gets a little heavier. It's basically about a 4 to 5 pound trigger is what it is. 4 pounds and change. So the science behind triggers, according to the studies, is that in order to prevent a negligent discharge, which is to say, in order to prevent you from accidentally or negligently pulling the trigger, you can have a heavy trigger or you can have a long trigger. In the study, those were equally effective, heavy or long. What you cannot have is a short and light. Now, obviously, for those 1911 guys right now who are pounding the keyboard, that's not to say don't carry a firearm that's short and light. It is to say that, of course, that needs to have a safety on it, right? So the trigger on my particular firearm, number one, is unmodified from the factory. It's done by it's done by a shop, so you've got that issue. That being said, I don't have a problem with modifying my own triggers. But number two is the fact it's a long and light. It's a very long and light pull. I mean, again, it's 4 pounds. It's not 4.5, maybe. It's not that light, but it's a long trigger pull. It's the way that the law enforcement modified or law enforcement modification trigger is on HKs. So I feel good about it. But to your point, could a prosecutor try to use it against me? Yes. At my point, I'm pretty darn desensitized about what prosecutors can do because I've seen them pull. I mean, I don't want to give him credit for having pulled everything, because there's always a little bit more water you can drain out of that pool when you think it's empty or getting there. And I'm sure by this time next year, I'll have more stories, unfortunately. But at the end of the day, what you want to do is you want to increase your chances of making a good shoot. And me being able to more effectively wield my firearm to put hits on target, that's a win to my mind. Can prosecutors use that against me? Sure. But prosecutors can and will use anything against you, basically. Mike Yu, another member or from before, asked, Tom, will they ever defund or abolish the ATF? So I had a conversation with Congressman Andrew Clyde on the channel that we published a couple weeks ago now, I want to say. The reason why I'm citing that is because, not to sound like Bill Clinton, but it may depend somewhat on what your definition of defund is. So Congressman Clyde, specifically with relation to the pistol brace issue, proposed stripping the funding of the ATF to enforce the pistol brace ban. So if something like that were to be passed, is that the definition of defunding? Yeah. Is it what I think you're asking me? Probably not. So do I think that the ATF could be defunded on something like that, kind of a case-by-case basis with a Republican administration? Sure. But a pro-gun administration, which I'm just going to simplify to say Republicans right now in today's day and age, a pro-gun administration, you generally don't see the need to defund, because the people in charge of the agency are generally much more pro-gun, or are at least not as obviously anti-gun as the current leaders are. Let's put it that way. So the result is you don't really need to defund in that sense. Now, I understand you need to defund the ATF. This is like the dragon sleeping. Why don't we just put it out of its misery? I get that. Okay. I'm not pushing back on that argument one bit. Okay. But my personal feeling is that there's a sizable enough minority within the Republican Party of elected officials who really don't care about guns. It's just something that they say on the campaign trail to get into office. And they don't want to expend political capital, or what they view as expending political capital, on a gun issue. And I think that's a big part of the hang up, frankly. So do I think that they'll ever do a mass defunding or abolishment of the ATF? If I had to choose right now, I'll say no. But you also have to be careful what you ask for. The reason why I say that is because what happens if they, one of the Republican presidential candidates proposed getting rid of the ATF, but that doesn't mean that they get rid of all the things the ATF does. They just get reassigned to other entities within the federal government. So is that a good thing or a bad thing? Would you rather have one entity that we've got to deal with all the time, or do you rather have a cross-section of entities we have to deal with, and they each have their own political agendas and issues, and any of them could be coming at you at any point in time, which they could do anyways, to be fair, but as explicitly part of their chartered mission statement. So I don't know. But as an entity, the ATF's purpose is the way that they can be used, obviously, and have been used, is as a political cudgel against the Second Amendment. So I generally don't see them as a friendly entity, that's for sure. Guys, I promised my wife that we would not be going as long this week, several hours. So I'm just going to hit a couple of these, couple more of these questions here. We've got Aaron Daly. Are you familiar with the Second Circuit overturning some of the carry laws? Yep, already covered that one. Robert Bennett, have you heard of any person carrying under LEOSA having problems in any state? Yes, I have. LEOSA is basically how law enforcement, retired law enforcement, gets to carry when they travel into different states. They're broadly not always subjected to local state carry laws as such. Anecdotally, I have heard about issues. Can I put my finger on it right now and give you specific time, places, and fact patterns? No. Maybe that's something I can kick into for you, though. That's kind of interesting. AW, follow up on the duty to retreat. I'm disabled now, lost a leg. Sorry to hear. Is duty to retreat different? Yeah, it's the written law remains the same, but the application of that law is entirely different for you, because the application of law now deals with the fact of, well, look, have you reasonably exhausted all of your opportunities to retreat? You may not really have an opportunity to retreat, depending upon how fast you are without that leg. So that's what I mean. Same thing for folks who are older or whatever the case may be. The Guns and Glory show asks, why is there zero accountability to people who take an oath and then violate our rights? Yeah, probably a combination of that is because lots of potential answers on that one. I think part of it is a division of powers issue, where individuals in one branch of government don't want to go after the individuals in another branch of government. I think part of it is getting into the club of being in government, and there's anticipations, there's expectations that you play and abide by certain sort of rules. I think that they would view it as they are upholding our rights. They have a very different definition of rights than perhaps you and I. And I think you start putting that all together and you start to get down the road of what that answer looks like. Ted Hall, how do we destroy this judicial fantasy of qualified immunity? Statutorily. Desert Punk asks, what do you think of 941.29 possession of a firearm 1MB? Well, 941 is the possession of the firearm in Wisconsin. Do I know off the top of my head what is the sub 1, sub M, sub B? I do not. Let's go to this. Oh, yeah. Yeah. Okay. So this is a really twisted and perverted thing that I really do not like in Wisconsin law. So you will be treated as a prohibited possessor in Wisconsin if you've been convicted of a crime in another state that would be a felony if you were convicted of it in Wisconsin. So a great example of this is Minnesota has what's called, and maybe I'm going to get the details slightly wrong here, but they've got something called like a class 4 burglary to a dwelling. So in other words, you broke into someone's house, you stole some liquor or their cabin or something like that, and you left. Not terribly uncommon to see cases in Minnesota that fit a burglary fact pattern pled down to that. And it's a misdemeanor. So people think that, hey, I'm accepting this plea. I'm not going to roll the dice at trial. So I should be good to go. I've protected my rights. I've avoided prison. I've protected my Second Amendment right. And then they get to Wisconsin. Wisconsin says, no. I think this law is insane. I think it's unethical. I think it's unconstitutional. And I think it needs to go. That's what I think about it. I don't think it's fair. I think it's grotesque. And there's plenty of other examples, too, of things that would be a felony in Wisconsin. You could take a misdemeanor drug charge in another state that Wisconsin will say any possession of that particular substance is a felony. Therefore, it's now a crime for you to possess a firearm in Wisconsin. So hopefully, Desert Punk, that gives you an answer to that. That's kind of what I thought that question was going to be when I went to the statute. This one is a super chat from Stephen R. Thank you, Stephen. Always great to see you. Odds next week for Illinois injunction to stop disclosure. Right. So we're dealing with, of course, the Protect Illinois Communities Act and whether or not we're going to go forward with the looming deadline a couple weeks away for mandatory disclosure, where you're facing, as I recall, a misdemeanor on your first offense. And then I think it escalates to what's called a class 3 felony on your second and subsequent offense. So arguably, if you have 2 firearms, is that misdemeanor felony, or did they catch you once misdemeanor and then they catch you again? Is that a felony? I don't know. Odds next week for Illinois injunction. Well, I think the odds of the Supreme Court doing something are pretty decent. The fact that Amy Coney Barrett seems to be proactive as the Seventh Circuit judge on this issue, both in the past as well as now. I'm going to say 2-1. They're going to step in and do something that we're going to at least kind of like. And man, I hope that's right. I really hope that's right, because that's a crazy law. But we'll have to see. We'll have to see. If that goes into effect, I've been calling for the better part of a year now that the Illinois law is going to be the law that's going to test the questions of so-called assault weapons bans, magazine bans, restrictions, and so forth. That's what's going to be going in there to test our rights. And for better or worse, what I called a long time ago looks like it's going to be correct. I'm on the whole happy about that, insofar as the Illinois law is, it could be worse. So for instance, the magazine restrictions set at 15 rounds, if memory serves, for handguns. Would I love to see it set at 5 rounds just to make it that much more crazy and extreme? Yes. So I would rather have it look a little bit better. Better in the sense that it's bad and more extreme and therefore easier to strike down. But we do have weird disclosure issues. It's possible the Supreme Court could weigh in only as it relates to the disclosure issue and leaves other things in place, or takes a piecemeal approach to it. I don't know. But this really seems like a binary call. Either Illinois, at the end of the day, is going to win, and there's a constellation of issues out there as it relates to the mandatory disclosure, as it relates to the prohibition of so-called assault weapons, as it relates to the prohibition and legal treatment of magazines. Are they protected by the Second Amendment, or are they not? We've got grandfathering provisions. We have all sorts of different legal issues just kind of boiling in this pot called Illinois. So it's possible we get a split somewhere in here. In other words, Second Amendment wins on a couple of issues, and the anti-gun civilian disarmament crowd wins on a couple other issues. I don't know. I hope, obviously, that doesn't happen, but I'm concerned that it might. Michael Dunn asks, how did your hockey game go last week? I don't specifically remember, other than the fact that we're on a 3-game win streak, so it must have gone pretty well. So thank you, Michael. Michael Foley asks, it seems that frequency of avid collectors and enthusiasts being approached by federal agents about their purchase activity has become a primary focus. Is anyone fighting this on a larger scale? To my knowledge, no one's fighting this on a larger scale. I don't know if the government agents and members of law enforcement are approaching people on a more frequent basis or not. There's obviously more reasons for them to approach people, because we've got bump stocks, we've got FRT, forced reset triggers, we've got pistol brace issues, we've got lots of different issues kind of out there. But I don't know. I see people getting approached on a reasonably frequent basis. Law enforcement's allowed to approach people. There's reasonably set laws on when it comes to reasonable suspicion, stop and frisk, Terry stops, probable cause, and all that kind of stuff. So as long as they are abiding within those, and again, I'm not saying I like this answer, but as long as they are abiding within those guidelines, I think it's not really so much a Second Amendment issue anymore. It's more of a kind of vanilla criminal law issue, if that makes sense. Chris Beck asks, assuming that 922 sub O, that's the machine gun prohibition statute, gets justly ruled unconstitutional, does the regulation on the books have a legal weight in the common use test? Does the regulation on the books have a legal weight? I think what you're getting at, Chris, is the fact that a lot of courts have cited to the fact that machine guns are dangerous and unusual. There's only 175,000 of them, which of course, yeah, they're unusual insofar as they've been highly regulated for the last almost 94 years, or part of 90 years. And they've been outright illegal for civilians to possess in any number of different states, and outright illegal for any civilian to take possession one manufactured after 1986. So in essence, we have a capped supply, which I can tell you there's less and less and less machine guns. If you guys like my interviews with Mike Kwiatkowski from fflexpert.com, he and I did a video. We did a bunch of interviews. So the way things get shot when we do interviews, oftentimes, particularly with Mike, is we'll shoot 3 or 4 videos at once, and then on slow news weeks, basically those videos come out. We shot one probably about a month ago now, where we talk about, maybe this was out there, I don't know, but it's about machine guns and the fact that each year thousands of machine guns disappear. They disappear because of lots of different issues. They disappear because people don't take care of them, and they rust and they fall apart, or maybe someone was an idiot and registered the wrong part and the part breaks, like a sear or something like that. I'd say a very common way that I see machine guns go away, unfortunately, has to do with lack of proper estate planning and knowledge, which just goes back to lack of estate planning. So someone owns a machine gun collection, oftentimes more than one. They pass away, and typically the inheriting spouse, if there's a surviving spouse, it's not really top of mind for them of, oh, I have to do a Form 5 transfer as a tax-free transfer to get the machine guns and whatever other NFA items into my name. Realistically, they almost never do that. So what happens is let's say the husband, as your stereotypical gun collector, that person dies. And then 7 years later, the wife passes away. And now the kids, who are oftentimes in their 60s or something like that, they're now the inheritors of these, in essence, unpapered machine guns. And they call up their estate planning attorney, who doesn't know anything about any of this stuff at all whatsoever. And that person will often panic and say, take him to the cops. So they take him to the cops, and the cops might chop him up. That's how we lose most of our machine guns. Thousands of machine guns per year is exactly that fact pattern. Or take out the gap between husband dying, wife dying, and just it's, the uncle or someone who maybe the spouse predeceased them. Everything's paper to them. They pass away. Everything goes to kids. Kids just don't care. They don't know what to do, or they get bad advice from their attorney, and so they drop it off at the cop shop or something like that. Or they take it to a friend who's got a way of crushing it and disposing of it. I see and hear this happening a lot. So that was actually part of what finally motivated Mike, who I've known for a long time now, to get on the internet, because he's a very private guy. This is very awkward for him to be on the internet, even though I think he does a great job. But it makes him sick how many times, unfortunately, he comes across situations where machine gun collections get destroyed because you get a bunch of individuals who don't know what they're doing and are risk adverse. And the combination of the two is, well, the only option where everybody's safe is if we just destroy everything. Probably every day that happens. Probably every day. So to get back to your question, Chris, because I got a little far afield there, I think 922 sub O, the machine gun ban, will very much remain in existence when it comes to pushing back on not only ongoing possession of machine guns, but furthermore, when it comes to the question of how do we characterize these weapons as being unusual. I do not have a rosy outlook on the change of machine gun status. I don't think it's going to happen right now. So, all right, guys, I'm going to do one last question. I'm going to throw in one more before that last one. So I've got Inverted Reality says, how do you square the fact that USCCA specifically excludes crimes from coverage under their contract. Isn't this the purpose of purchasing self-defense coverage? Yeah, so that's a pretty, and I'm not putting this on you to be clear, because I realize that you're not the inventor of this question. But I think that the people who took that almost deliberately obtuse reading of a lot of the non-criminal civilian protections, like for civil law, my understanding of the insurance side of it, which is code for I'm not an insurance law attorney, but if you get convicted on the criminal law side, then there's probably no way for any insurance company to represent you on any ensuing civil law side. I know attorneys on retainer hype the fact that they can represent you in civil law side. That's a complete shoulder shrug to me. Do you know how many times I've ever seen anyone get sued civilly? Like, it almost never happens. So it's something to think about. I know it's something that I bet insurance companies, they probably all like to talk about it, because I'm sure that you can talk about how many tens of thousands of dollars or millions of dollars people could get sued for. And I'm sure that I'm sure it sells coverage, but we represent at any point in time probably between about 4 to 15 people in defensive gun use cases. And I don't even know how many others I've talked to over the years. I mean, Lord knows how many. Keep in mind, depending upon which study you want to keep in mind, there's between 500,000, almost 3 million defensive gun use cases in the United States every year. That's a lot of defensive gun use cases. There are comparably virtually no civil lawsuits. So if you were charged with a crime, and if you have a semblance of an argument in self-defense, any of these companies should be representing you. We've had any number of times where our attorneys, when they talk to an individual who is a USCCA member, has said this doesn't sound very self-defense-y, and the USCCA still extends coverage. I'm being told by Derek to mention the fact, because I'm really bad at this, that we've been nominated for Gundy's Awards. Gundy's Awards are basically the awards that YouTube channels basically get nominated for. And then there's an award event on January 22nd. It's part of SHOT Show. It's a separate industry and event, but it happens during SHOT Show. You're allowed to vote once per day. I think this is the end of the voting this week. We're nominated for 2 things. We're nominated for, I think, Top Voices of 2A, as well as for Breakout Content Creator of the Year. I candidly don't expect to win anything. It's fun to be nominated. But if people felt so inclined, it's absolutely free to vote. I think the website is thegundys.com. If not, yep. Thank you, Tom. Thank you, Tom. Tom Rolfson, longtime friend of the channel. Great guy, great concealed carry instructor if you're in southeastern Wisconsin as well. So be sure to hit that as well. I know some of these other channels are hitting it once per day. I think this is now the 3rd time I've mentioned it in the last month. So probably should do that better. All right, now one last question. And I'm going to look to the comment field. So I'm looking at the comment field live, guys, putting my eyes on that. The last thing I see is from the Guns and Glory show that says Suppressors 2. Who's got another question here? Hopefully it's a good one. That's right. Yeah, Tom is a great guy. Tom Rolfson, I'm not saying I'm a great guy. He and I frequently, I don't know how it happens, but we frequently bump into each other at a couple different gun stores. One of them being North Star Gun Works, great gun store with 2 great guys in Waukesha County, Wisconsin. So just down the street from my office. Can we meet Jen? All right, guys, comment. So for those of you who don't know, Jen is actually an emergency room physician. She has treated gunshot wounds, stab wounds, both in the field as well as in the hospital. I keep telling her that she should come on and do some shows talking about how do you stop the bleed and all that kind of stuff, and can really go into lots of different details. Speaking as someone who hasn't researched this academically of apply pressure and elevate and that kind of stuff, but could go into some pretty gnarly stuff. So do you guys want to see Jen come on the channel and do some discussions on this? Should we pry her into doing some interviews, whether it's about this or maybe about being stuck with me? I don't know. Throw up some. So yes, yeah. She's reading this right now. I'm sure she's like laughing and rolling her eyes in another room. Yes. Okay. All right. We'll see if this video gets enough likes. Maybe if we can get 500 likes or something, we'll see. And I'm arbitrarily calling the shots. Hopefully, I set a reasonable target that's achievable, and hopefully we can get that. Do you guys want to see Derek as well? By the way, Derek's is our behind the cameras guy. Occasionally, you see his arm or hand, something like that. Do you want to see Derek come in to do an interview about something or other? We got a very meaningful sure about that. Yeah. All right. We'll see if we can coax Derek in front of the camera. We'll see if we can get Jen in front as well. Maybe what I'll do is I'll start a community section tab. So again, that's where I post the quotes of the day. So I think generally speaking, if you click on like my picture when you're on any of the videos, that should bring you to like my YouTube channel homepage. And then what you do is you click on the community tab, which is kind of towards the right. And then that's where you see where I post like quotes every single day. So maybe what I'll do is right after, as soon as I get off of this, is I'm going to start a community tab section. I think I'm going to call it, or a post rather, like questions for Jen. And that's, guys, where you can throw up your questions. And we'll see if we get enough interest and all that kind of stuff to lure her in front of the camera. She's a science girl. She graduated first in her class to medical school, which is code for I think she enjoys, although she would never admit it, but I think she enjoys being in front of the camera, but she does not like public speaking. And I know it makes her nervous. So, but maybe with enough support, we can make that happen. So, I think the official first question I saw, will the Vikings win the Super Bowl? No idea. Sorry. I'm not one of those sports guys or anything like that. I just 6 kids, everything else. I just don't have time to watch sports. I watch the NHL. It's kind of what I watch every now and then, basically highlights. So, all right, guys. Well, appreciate your time. Don't forget to hit that like button. Throw up comments after this video is done. So right now we're in the comment section right now. These comments, of course, will be viewable to anybody who is watching this video and chooses to go back on the live. But after this video is done, how YouTube will rank this is they'll be looking at how many people also post comments like, below the video, just like normal, right? So be sure to, if you felt so inclined to help us out with the algorithm, that's always a place to do it. I'm searching right now for a quote of the day because once more, I'm not on top of this. This one comes from Roman Emperor Marcus Aurelius, one of my favorites. Confine yourself to the present. Marcus, always coming through. Well, as always, really appreciate it. Let me know after this video is posted. Here's something you can post in that. Let me know if you want to see this video series rolling on these live Q&As. Also, whether or not you would rather see this be evenings, weekends. I'm kind of picking this time because this is when our kids are napping, frankly. But if there's another time you'd like to see, post that up in the video. Guys, from myself, from Jen, from Derek, from all of us, thank you for joining us. This is actually kind of fun. So hopefully you got something out of it, and we will see you next time.